The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And good morning. We have 5 cases that will be submitted this morning. They are State of Iowa versus Carrie McIver, State of Iowa versus David Halstern, In re the Marriage of Gust, State of Iowa versus Young. The final case is Shelby County Cookers versus Utility Consultants International, Inc. The last case will be submitted without argument. Before we begin, I would like to welcome the students from Des Moines Hoover High School and Central Academy who are in the audience today to help us all celebrate Constitution Day. I would also like to welcome all students across the state that are watching these proceedings on our live stream. The Iowa Constitution defines the individual rights and liberties for Iowans, all Iowans, including high school students, just as our Constitution of the United States establishes our fundamental rights that we enjoy as all Americans. The first 2 cases that you will hear this morning do involve constitutional issues, and they illustrate how these rights that have been with us for centuries can remain so relevant in our lives today. We hope these cases will give a better understanding and appreciation to the importance of our Constitution in our lives today and in our future tomorrow. We'll now hear the arguments in the first case of State versus McIver. Mr. Brown.
Thank you, Your Honor. May it please the Court, Counsel. My name is Brandon Brown. I'm with the Parrish Law Firm, and I have the pleasure of representing Carrie McIver on her direct appeal. In our brief, we raised 2 issues. The first, as the Court had indicated, is a constitutional issue, and that's whether law enforcement possessed the requisite probable cause or reasonable suspicion to stop her vehicle. The second issue is whether Iowa Code Section 321J.6 Sub 3 imposes a duty on law enforcement to request a blood or urine specimen when presented with reasonable grounds to establish a person may be under the influence of controlled substances or a combination of controlled substances.
Can I ask you a procedural question?
Certainly.
The appendix shows that you stipulated to a trial in the minutes.
Correct.
But the order says it was a guilty plea.
Yeah.
And if it was a guilty plea, and that's on page 50 of the appendix, and if that's the case, don't you waive all these issues that you made if it was in fact a guilty plea? And that's what the record shows in this case.
And if I'm looking at page 50, the order, OWI sentencing order, there was some boilerplate language in...
I'm sorry, 49. It says order accepting plea to OWI in sentencing. So it appears to me it was a guilty plea, not a trial on the minutes. And if that's the case, don't you waive those arguments?
We would. However, there was a colloquy with regard to the trial on the minutes as reflected in the sentencing order where that language was changed. And I don't know if that was a Scrivener's error on page 49. But if you look at page 50, it indicates that the defendant is found guilty rather than pleads guilty. And then it indicates in the trial information and minutes talking about, based on the statements, how the court found that the defendant was guilty. So we're asserting that it was a trial on the minutes. I don't know if that issue was raised by the state. I appreciate the court bringing it to our attention, but it appears that it was simply a Scrivener's error when we prepared the order on page 49. Getting back to the issues, I'd like to focus on the second issue because from what it appears, that's a case of first impression, or this is an issue of first impression, which is why we're presenting it to the Supreme Court here today. And in order for us to advance our argument, we first must...
Counsel, are you conceding that there was probable cause or reasonable suspicion? I mean, after all, the officers saw the vehicle drive up over a curb and onto a lawn. Are they supposed to let that go in the middle of the night?
Well... Certainly under the probable cause standard, I haven't identified, and I don't believe that the code sections that have been identified provide probable cause for law enforcement to stop or detain that vehicle.
Well, what about reasonable suspicion of intoxication? Is it 2:40 in the morning? My timing might be a little bit off, but it's early in the morning, and you see a vehicle drive off a parking lot and obviously onto the grass and jumps onto the street in some fashion. And then it weaves somewhat. Now, I think you're right. The weaving under our case law, standing alone is probably not enough. But what do you make of this driving across the grass and jumping the curb at 2:40 in the morning? Doesn't that take it beyond a hunch and into reasonable suspicion?
Well, I think my reply brief addresses whether particularized reasonable suspicion can arise from a vehicle being at a closed business alone at night. And
It's not just that, though. I mean, in isolation, each of the facts are inadequate to be reasonable suspicion. You kind of move them back and forth probably is not adequate. Being in a closed business parking lot might not be adequate. But when you put it all together and add to it what seems to be kind of an unusual event, that is driving over the grass and onto the curb, give me your best argument why that still is just a hunch and not reasonable suspicion.
Well, it's a hunch because it's not daylight, it's nighttime. There was no evidence indicating that this was a well-illuminated or lighted area. It simply could have been a mistake where the person who was driving off drove across some grass and drove into the roadway. Again, from what we can tell, there's no violation of any code section.
It doesn't have to be. It has to be reasonable suspicion of drunk driving, for example.
Understood. But I think that simply being parked in a location like that and driving over a very small piece of grass onto a roadway still is an unparticularized or hunch as to what's going on. And then when the officer follows the vehicle, my assertion or my best argument is that the officer pulled the vehicle over too soon. Because, like you had indicated, the weaving in of itself under our case law and corresponding case law from federal jurisdictions in other states indicate, you know what, that's not going to be enough. So perhaps it was premature or not yet right to stop the vehicle because even the culmination of events would not rise beyond anything other than an unparticularized or general suspicion. So I've briefed that, and most of my arguments and all the facts and the law I have in there, I'm simply just kind of rehashing that. But what I would want to focus on is this issue on the Applied Consent Advisory in 321J.6 sub 3. And as I indicated before, we have to demonstrate there are reasonable grounds to believe that Ms. McIver was either operating a motor vehicle while impaired with controlled substances or a combination of controlled substances and alcohol. And I'd like to touch on just a few of the facts that would support this threshold determination. As we've discussed, it was evening hours. Sergeant Toby was out on routine patrol. He saw the vehicle that we've discussed and described in a closed parking lot. It drove over some grass and it started to weave as it drove away. And I believe that Sergeant Toby indicated that he observed the weaving for a matter of seconds and decided to stop the vehicle. He approached the vehicle, and when he got up to the driver's side door, he learned that there was a driver, Carrie McIver, and 3 occupants in the vehicle. He asked Ms. McIver for her driver's license, proof of insurance, and registration, which, as we all know, is a divided attention task. Certainly the officer wants that information, but it's also designed to determine whether somebody is impaired, because if you grab 1 or 2 or grab the wrong materials, that is a clue under Iowa law and under the guidelines promulgated by the Iowa or National Highway Traffic Safety Administration as a clue of impairment. There's no evidence in the record that she had any problems procuring these items. However, the officer does indicate that he felt that her mannerisms were, if I could quote him, were a bit off. And when pressed, he had indicated that she was processing slowly, she had slurred speech, and she had an inability to follow directions or stay on task, despite the fact that the brief encounter they've had thus far face-to-face demonstrated that she had no issues on providing that material.
When does the record reflect that she first advised law enforcement that she had been taking medication or had any type of prescribed medications?
Under the record, well, I mean, the record is developing through nonverbal clues, but as far as her directly advising law enforcement, the record reflects that it was Deputy Lumley when he had invoked the implied consent advisory down at the station where she had indicated that she had a rotator cuff injury and that she was taking, I think it's Flexerol for that.
Why didn't she advise the officer immediately upon the stop or when they start going through all the different tests by the roadside? My understanding is she had been babysitting. The other occupants had been at a party, drinking. He didn't smell any alcohol on her. Why wouldn't her normal response at that time be, I haven't been drinking, I've been babysitting, and I'm on medication that may have affected my driving? And
I know that Sergeant Toby had denied that he received any information that she was taking some prescription medications. I mean, it's difficult for me to speculate, but at that point when she's down at the station and she's confronted with the potential loss of a driver's license for 6 months to a year, maybe perhaps at that point it dawned on her that this is the time that I really need to be adamant, which even Deputy Lumley indicates she was adamant about getting a blood test because it's the most accurate test because she was taking those. But it's also important to note that during the court, and I'm going to skip ahead a little bit, but after the PBT was refused and she was taken down to the station for further testing, Sergeant Toby did conduct an inventory search, and he discovered that there were 3 prescription bottles in her purse, one of which was identified as oxycodone, and as Sergeant Toby recognized during the suppression hearing, that is a central nervous system depressant, similar to alcohol. So getting back to establishing the reasonable ground standard, when Ms. McIver was asked to exit the vehicle, she performed 3 standardized field sobriety tests. And it took approximately, I think, a minimum of 20 minutes to proceed through the testing period. And as we discussed, Sergeant Toby was in close proximity to her when administering the horizontal gaze nystagmus test. You're face-to-face, essentially, and there was no detection of...
Let me ask this question. Assuming at some point the officers had reason to believe that there may be ingestion of prescription drugs going on, triggering, as I read it, the statute. At that point, there is a duty to allow for a blood or urine test. But does that mean that you can still refuse to take other tests?
We're jumping right into the reading of the statute. I appreciate that. We're looking at the first clause of subsection 3 that says, notwithstanding subsection 2. That says, to me that means, in other words, despite or in spite of. So yes, I think that, or our argument is, since it says notwithstanding, if you have reasonable grounds to believe that a motorist is under the influence of a controlled substance, a drug, or a combination with alcohol, that yes, there is an obligation to conduct or offer the urine test or the blood test.
Let me try an alternative reading of that provision that I think is maybe a more reasonable one. Subsection 2 says the police officer gets to determine which test. Police officer here selected breath, your client refused. Subsection 3 says, notwithstanding subsection 2, like you say, if the peace officer has reasonable grounds to believe the person was under the influence of a controlled substance, a blood or urine test shall be required even after another type of test has been administered. Here, no other test was administered because your client refused. And if you think about it, I think that reading makes sense because it doesn't, otherwise your client gets kind of a pass on the breath test, and also otherwise your client can be in a situation where the officer has to invariably, if there's any drugs around, has to be equipped to perform this additional test. Why isn't that a proper reading of the statute?
I think an officer is allowed to first offer a breath test, but under subsection, or under 6 sub 3, it still says they shall offer or provide, I forget the exact verb, the blood test or the urine test. And a blood test or urine test isn't really getting around the breath test because alcohol will still be detected in that specimen.
Oh, but the heart of the question, it seems to me, is, is the blood or urine test kind of exclusive, or is it cumulative? Is it stacked? I mean, you could still request a breath test, and that may trigger informed consent doctrine. And if you refuse the breath test, you may be in a problem. But in addition, you're entitled to a blood and urine test. I mean, you're saying, obviously, subsection 3 is kind of the exclusive testing, blood and urine. You can't do anything else. But why couldn't you also read the statutes in a stacked fashion rather than exclusive fashion?
I think because of the exact set of facts that we have in this case. It's clear from the testimony from both Sergeant Toby and Deputy Lumley that they were focusing on alcohol and alcohol alone. And neither one of them were drug recognition experts. And I believe that even Deputy Lumley had indicated he's not sure whether either, I think it was a blood test or a urine test, will detect prescription medication. So if you make it mandatory, then, and it's very interesting, if you, at a minimum, I believe that the statute's ambiguous. And if it's ambiguous, we should be looking at the intent. And when it's not always been a shall. It was a may back in, I believe, 1998. It was amended to a shall at the exact same time that the legislature imposed the affirmative defense, which I believe at one point was under Iowa Code Section 321J.2 sub 7. Now it's 321J.2 sub 12.
That makes a lot of sense, because you don't want to have someone be charged under the influence of drugs and be deprived of the defense when it's a valid defense that you took the right amount and you did it under a doctor's prescription, because that was a safeguard to the individual. But, going back to the question that Justice Apple and Justice Manfield have asked, doesn't subsection 2 of 321J6 give the officer the absolute right to decide which test to give, whether it be the chemical or the breath test, and a refusal thereof is a problem? And doesn't that kick in first before subsection 3 kicks in?
I think it applies when we're talking about alcohol alone. But when we're talking about either controlled substances or a combination of both, then subsection 3 is the applicable subsection. And I say that because, for example, in this case, let's assume for whatever reason, whether Ms. McIver was stubborn, she was uninformed, or she's confused, she didn't know why, but she decided, I'm not going to provide the breath specimen pursuant to implied consent. I want to give the blood specimen. What happens is she's being deprived of exculpatory information that would otherwise be allowed under her affirmative defense.
Doesn't she have a right to an independent exam?
She does, but not many people are advised of that. I don't think it's a requirement under 321J.6 when the duty of officer to advise of revocation proceedings, and that's not included. People are not aware, and I believe that when you look at the intent of the legislature, they put both the affirmative defense in there as well as the mandatory requirement for obtaining the the blood or the urine, so that it can be preserved for an affirmative defense, because it would apply both to administrative and criminal proceedings.
Thank you, Counsel.
I see my time is up. Thank you.
Ms. Chambers.
May it please the Court, Counsel, I am arguing this case today on behalf of the state. Joe Williams, our student intern, wrote the brief, but he is now back at school. I'd like to just clear up a couple of things on the reasonable grounds for the stop, and then I'd like to focus my argument primarily on the statutory construction. The district court found that the stop was lawful based on 3 grounds, any or all of which could be upheld on appeal. It found reasonable grounds to stop for reckless driving, failure to drive in the lane, and also operating while intoxicated. I would point out only one thing, and that is that in the state's brief, we did not rely on the 321-297, and so I think we've effectively abandoned that argument on appeal. I'm not conceding that it would not be an appropriate argument, but we didn't make it. Turning then to the statutory...
What statute is violated when someone leaves a parking lot by driving over the grass, driving over a sidewalk, jumping the curb, and entering the roadway?
Probably a whole bunch of them, Your Honor. But at least it violates reckless driving in that it creates a danger to property, not
Is there
to
a
people.
specific rule of the road that's violated?
Yeah, I do, although we didn't argue it in our brief, I do think it violates 321-297.
Let's keep to what's in the brief. Is it really reckless? I mean, maybe it depends on the facts and circumstances. You might have to tell me what's in the record, but many of us have driven over pieces of grass, maybe clipped a corner or some such thing, or hopped a curb on occasion. If there's no traffic, if you do it, kind of carefully, albeit maybe mistakenly, that's not reckless. What about the record, would you cite to convince us that this was really reckless rather than just an occasional mistake that wouldn't arise to recklessness?
The record isn't great on that issue, which is one of the reasons that the state is choosing today to focus on the reasonable grounds for suspicion of OWI. But it was dark. He cut across the grass. He easily could have torn up the grass because it doesn't have to create a danger only to people. It can also create a danger to property. So he could have torn up the grass.
But there's no evidence he was going at great speed. I mean, he's just rolling off as far as we know.
I think the officer said something like quickly, but no, there's not a great deal of evidence about how fast or if there was any damage or if the ground was wet. And so again, while I do think in many circumstances and perhaps here that statute would be violated, the state really chooses to focus on what is clearly supported by the record, and that is reasonable cause to believe that the defendant was driving while intoxicated. Because those very facts, even if they wouldn't rise to reckless driving, certainly support a belief that the defendant was intoxicated. It was shortly after the bars closed on Saturday morning. The car was parked in the parking lot and then drove across the lawn to get out to the street, which is both evidence of erratic driving and evidence of impaired judgment. And then was weaving within its lane. And then after the officer activated its lights, it jumped the curb twice, and when it tried to turn the corner, it jumped up over the curb.
Well, the seizure starts when the lights are activated, I think, though.
No, the seizure takes place when the defendant stops. Until the defendant stops, you have only an attempted seizure. I think Hodari D is very clear on that point, and Iowa case law has always followed that. Although we don't need it, let me be clear, we do not need this. But in terms of justifying the stop, the state is entitled to rely on everything that happens before the defendant actually comes to a stop and submits to the officer's authority. Everything before that is merely an attempted stop. And so the Fourth Amendment does not apply, and Article 1, Section 10 of the Iowa Constitution does not apply until the defendant stops. Turning to the implied consent argument, I think that we should start with looking at the purpose of that statute. 321J.6 is intended to tell the defendant, or tell drivers, I should say, what it is they consent to when they choose to drive in our state. It's telling the driver, if you drive, and if you do so under circumstances which give officers reasonable grounds to believe you're intoxicated, then this is what you're consenting to. You're consenting to a test. The officer gets to determine which test. If you take a test, you are entitled to an independent test.
What is the purpose of the amendment, Section 3?
The part that amended it to say shall instead of may?
Yeah, what was the purpose of that?
I think it was just to clear up that that is not permissive, that the defendant can't choose not to, that it shall be administered if the officer asks for it.
It seems to me, I think there's a little bit more to it, in that the purpose it was shall, and it was ordered to preserve evidence for the defendant, number one, to show his or her affirmative defense that the drugs within their system were within the normal limits, therapeutic values rather than non-therapeutic values, and at the same time allow the state, in making their charging decisions, once they had it, to say, well, maybe we shouldn't charge on this because there was a valid prescription and they were in therapeutic values. And I think that is more the purpose than just clarifying shall be may, and tell me where I'm wrong.
Well, there are a few reasons that the state believes that's not the correct interpretation. First of all, you don't even get to paragraph 3 unless there's been a test consent. So if the defendant, as Ms. McIver did, refuses testing.
But if we find it ambiguous, we look at the purpose and intent, and we may say you get the 3, even though 2 may have some language to the otherwise. And that's the bothersome part to me. I mean, I don't think it's clear. I mean, we could read 3 either way. I think if you read either way, reasonable persons can read it every way, and if it is ambiguous, then we have to look at the intent of the legislature. And the intent seems to me to preserve that evidence for both the state and the defendant.
I think one of the reasons that isn't the most reasonable interpretation is, if you look at the very next sentence, it says, the language in question says, shall be required. Then the very next sentence talks about what happens if the test is not administered, and that's license revocation. It doesn't say that the refusal or the test results can't be used. It just says if that is not complied with, the remedy is license revocation. So that indicates that the shall be administered is not referring to the officer, but to the driver.
Counsel, let's focus on the words in subsection 3, shall be required even after another type of test has been administered. Isn't it a plausible reading of that phrase to understand what the intent is there is to say, if the breath test is refused, you still are entitled to the blood or urine, or if the breath test is performed, you're still entitled to the other 2 options, or they shall be not entitled to. They shall be done, whether or not the breath test is done. It just seems to me that's also just as plausible a reading of that language.
Let me give you the court an example of why I think that cannot be what the legislature meant. Okay, so we have a case like this one where there's clear evidence of impairment. The officer did not believe that McIver was impaired by a drug. He believed her to be impaired by alcohol, so he asked for a breath test.
But he didn't smell any.
He smelled it coming from the car. They admitted they were coming from a party.
But that's a police error. That's a policing error. That's his bad judgment, maybe, that he thought there was alcohol there. I mean, we have a defendant here who has certain constitutional rights and certain statutory rights, and should she be penalized because of the officer's bad judgment?
Sure, but I'm giving you a hypothetical. So the hypothetical is that the officer stops someone, let's say he smells alcohol, he sees signs of impairment. Unless he's a DRE and actually goes through the DRE testing, that officer doesn't know necessarily what all the defendant is impaired by. So that's one of the reasons why the prescription drug defense is not available if you've consumed any amount of alcohol. Okay, so this officer, though, believes that this defendant, in my hypothetical, is entirely impaired by alcohol, no drugs. So he goes through the testing, he invokes the implied consent and asks for a breath test, and it tests really low, or it tests 0. So then he would ask for another test. But if it tested above, or it tested low, but there was enough impairment to make a test, and he still doesn't believe there's any drugs, he will charge the defendant and go away. But 3 weeks later, the defendant may say, hey, but I was impaired by a drug. And if you had looked and you knew that there was oxycodone in my purse, and so even though you had no reason to believe I took it, reasonably you should have.
The answer is easy to that one, because if the breath test comes back near or over the limit, I think the proper remedy would be when the officer fails to give the chemical test. I mean, the blood test is that you could only charge him with operating by under the influence of alcohol, not by operating under the influence of drugs.
He didn't.
I'm just saying that would be the remedy in that case, because you deprive the defendant of their blood test, which was required by law. So that's an easy answer to that
I think the remedy in my hypothetical would be the defendant would move to suppress the test or the refusal because the officer didn't offer that second test. If you look at every single OWI case decided in this state, the underlying theme is that here's what happens. You drive under circumstances that would justify a stop and justify implied consent. The officer can, if he chooses to, invoke implied consent and request a test. And despite the fact that paragraph 1 says tests shall be administered, we've never said the officer must invoke implied consent. But if he does, or if she does, here's what happens. The officer picks the test, the defendant gets no choice with the exception of blood tests. I'm
going to interrupt you at that point just because this is a concern of mine, and I know it's a little bit of word game here, but the first word of subparagraph 3 talks about notwithstanding. What is your definition? I have a couple of myself, which is sort of like irrespective of subparagraph 2 or in lieu of subparagraph 2 or regardless of subparagraph 2, which seems to me that it's sort of a mutually exclusive, that if then he has a reasonable suspicion that, which by this time he does, that she may be under the influence of other substances, doesn't that kick in subparagraph 3?
I don't. I read it this way. Subparagraph 2, first of all, it means that even if a test has been given under 2, one can still be requested under 3. So notwithstanding that number 2 says shall submit to a chemical test, which would imply a single one, there can be a second one notwithstanding that. And also notwithstanding that part of section 2 that says you can refuse a blood test without penalty, you cannot refuse a blood test under subsection 3. If the officer says I want blood, you give it or you lose your license. Under 3.
Isn't the reason we're here today is because the officer sort of goofed up, didn't really recognize this might have been a drug thing and offer the test, and now you're asking us to read these statutes to cover this one situation, which may lead to untoward results in other cases.
I could not agree more strongly, Your Honor. This officer didn't ask her up. He saw a clearly impaired driver, stopped her, requested a test, and she refused. End of discussion. Also, let me point out that the only thing she admitted to taking was Flexeril, and there's nothing in the record indicating that that's a drug that would impair her driving. She says it's a muscle relaxant. So,
the officer said it's a central nervous system depressant. That's always going to have some potential impact on your driving, isn't it? Just like any other, even over-the-counter medications that you may take.
I don't think the record says that.
Well, whether or not it does, she says I'm taking Flexeril, but in her purse is oxycodone, and that clear, there's no dispute about that.
Right, but she never claims to have taken that. Not during the time of the investigation. She suggests later, although she didn't testify that at the suppression hearing, that she took that.
Is it your position that if she doesn't admit to the officer that she's taken it, the mere fact that she has that drug in her purse doesn't rise to the level of reasonable grounds to believe she's taken it?
That is my position. So let's say the officer stopped her for driving and there's no evidence of intoxication, no evidence of alcohol intoxication. If the officer said, hey, you've got oxycodone in your purse, I think you're impaired by oxycodone, we'd have the fastest motion to suppress you ever saw, because any defendant would be arguing the fact that I have a prescription drug in my purse is not reasonable grounds to believe I took it and then drove. I think if you reverse that situation, it's pretty easy to see.
You don't think there's real suspicion when someone's driving erratically and does these things and the court finds a oxycodone prescription on them, that's not reasonable grounds to do the blood test? I don't think you'd be arguing that if you were here on that case, and I know you wouldn't be arguing that.
I don't know. I mean, we have to look at all the circumstances, but certainly the defendant would say that's not enough. At any rate, the notwithstanding language, Your Honor, is intended to say, okay, so while you can't be penalized for rejecting blood under 2, you can under 3. And while 2 says a test, 3 says there can be a second test. That's what notwithstanding paragraph 2 means. I see my time is up. I'll stand on my brief.
Thank you, Ms. Chambers. Rebuttal argument?
Thank you, Your Honor. May it please the Court. I think one thing we can all agree on is if the subsection 3 was written in an active voice or the passive voice, we probably wouldn't be here today. However, it wasn't, and I think at a minimum what we're establishing is that it's ambiguous. And in addition to trying to get effect to the legislative intent, I want to draw another maxim that the Court must be mindful of that's found in the State's cited case of State versus Schultz at 604 Northwest 2nd 60, which is when we're talking about criminal statutes and ambiguity, they're to be strictly construed with doubts in favor of the defendant. So at a minimum, in addition to trying to discern the legislative intent, we also need to be looking at, well, if it's ambiguous, the tie goes to the proverbial runner, and in this case, the defendant...
This is technically not a criminal statute. It's part of the regulations governing drivers. It's part of the fabric of OWI legislation, which we have often said is implied liberally to protect people on the road from drunk drivers.
Yeah, it falls under Iowa Code Chapter 321J, which there's administrative penalties, there's criminal penalties. Again, I would respectfully submit that this is a criminal or quasi-criminal statute. It certainly has criminal implications, and anytime we have criminal implications, we should be resolving any doubt in favor of the defendant.
Counsel, let me ask you this question. If a driver is pulled over suspected of drunk driving and the driver produces a prescription bottle, is that going to require the officer to, under your interpretation of this statute, is that going to require the officer to demand a blood test?
No, Your Honor, we have to have faith in the reasonable ground standard, and that's satisfied if a peace officer is aware of facts and circumstances that would warrant a prudent person in believing that offense has been committed. Let's look at this case. We have an officer who spends 20 minutes next to a motorist. He doesn't smell any alcohol at all. Yet she fails 16 of the 18 clues. There's oxycodone found in her purse. She acknowledges that she's taking Flexerol to the officer, invoking implied consent. Neither one of these officers are drug recognition experts, and they have no idea how the impacts of medication affect field tests. So when we look at whether somebody simply, makes the self-serving statement of, I'm on medication, well, you still have to look at the reasonable grounds and the facts and circumstances that are presented to the officer. And in this case, there's overwhelming evidence that Ms. McIver...
Well, it's a violation to have a combination of alcohol and drugs in your system. So I'll go back to my question. If in the process, even if the officer smells alcohol on the breath of the driver, if in the course of the investigation, the officer also becomes informed that there's a prescription bottle in the car, is that going to then invoke subsection 3 and require a blood test?
The way that the statute's written, it appears that it would, because it indicates not just controlled substances, but also a combination of alcohol and controlled substances. If that's something that needs to be addressed later, that might be best left to the legislature. But
and why would the legislature want to zero in on this particular issue?
Could you clarify when you...
Well, why would the legislature be interested in mandating a certain type of test in the event that there's reasonable suspicion that drugs may be involved?
Not every officer is a drug recognition expert. In fact, a vast majority are not. So there has to be some sort of test or some sort of policy implemented to make sure that individuals who are under the influence of a controlled substances, as directed by a physician or a pharmacist, are not criminalized or penalized criminally for having that in their system.
Well, the state is set up for breath testing. We're not really set up. I shouldn't say we. The state is not set up for blood testing, and so the breath test is the predominant way which we go. But would we be requiring a whole new layer of testing if we were to interpret the statute under your approach?
Potentially, but we're set up for breath testing, which is the easiest test. But obviously, we all will agree that doesn't detect ingestion of controlled substance like a prescription medication. But the blood test is the outlier as being the most logistically difficult. We still have the urine test, which is...
And by far the most expensive.
Agreed, by far the most expensive. But even as Deputy Lumley had indicated in his testimony at the suppression hearing, he had what's called a NIT kit, or a urine test kit, that was readily available to him that could have easily disposed of our issue here today if he would have offered that. However, as he indicated, he was not going to or had any intent to.
Counsel, looking at the purpose of this statute, we're talking here about instances where there's reasonable suspicion or grounds to believe that the person might have been using a controlled substance that is prescribed. But the purpose of this statute is a lot broader than that, isn't it? It's also to empower the officer to demand blood or urine if there's a suspicion that the driver is using some other kind of drug, methamphetamine or other street drug.
Exactly.
It's a lot broader than just prescription drugs, isn't it?
It is. I'm talking about it in the context certainly of Mr. McIver's case, but you're right. Based on the language of the statute, it is broader and does include and encompass street drugs and illegal criminal narcotics.
And that's clearly one of the important purposes behind subsection 3, right?
Yes, but keep in mind that someone who's taking methamphetamine is unlikely to have an affirmative defense available to him or her.
Excellent point.
Could I ask one follow-up question? And following up on Justice Wiggins' question, what would the remedy be if you're correct that she should have been offered a blood or urine test? Wouldn't it simply be that the state could not prosecute her for a drug violation but could still proceed with the alcohol prosecution?
I mean, the way that obviously this issue has not come up before, so there's no real guidance as far as an exclusionary rule application, but it seems to me that this court, since maybe the 70s, has applied an exclusionary rule to a violation of implied consent, as referenced in, I think, the last or second to last case of my brief, and so we would assert that the exclusionary would apply to this violation as well.
Thank you, Mr. Brown.
Thank you.
Case of State versus McIver is now submitted, and we'll next hear the arguments in State versus Hellstrom.